Hi, welcome back to La Belle Vie. Today I'm revisiting the case involving the murder of Tampa Bay attorney Steve Cozzi on March 23 of this year, allegedly at the hands of Florida plastic surgeon Dr. Tomasz Kosowski. Now, my first video in this case, which I'll link above, occurred right after Dr. Kosowski was arrested. Now, subsequently, on April 27th, Dr. Tomas was indicted by a grand jury for a first degree murder charge, and the state has filed a notice of its intent to seek the death penalty. Now, sadly, Dr. Cozy's body has yet to be found as of today's date. My heart and thoughts go out to his husband, his family, his friends, and his colleagues, because I always want to keep the victim first and foremost in mind. However, there have been some updates on the defense side. Last week, Dr. Tomas's attorneys filed a motion to dismiss the indictment and a motion to set bond. The court has scheduled a status conference for next week regarding the scheduling of these motions. So today I'm going to go over the motion to dismiss and the motion to set bond and provide my initial input. I also have a few other updates regarding Dr. Tomas's representation and the status of that civil case that is still pending. You'll recall that that is the civil litigation that Dr. Tomas brought against his former employer. And that former employer is whom Steve Cozzi was actually representing in the litigation. And you probably won't forget that chilling fact that it appears that Dr. Tomas allegedly might have been in the law firm's parking lot and participating in a Zoom status conference for that civil case that morning when when Steve Cozzi was allegedly murdered. So, without further ado, let's go first with the motion to dismiss the indictment. So, here's the motion to dismiss the indictment. And basically, he's filing this motion to dismiss pursuant to Federal Rules of Criminal Procedure 3.140 and 3.190B, and also under authority of the US Constitution and the Florida Constitution. So basically, what he's saying there is on or about March 21st, 2023, the alleged victim was reported missing. The alleged victim has not been seen since that time. Dr. Kozowski was developed as a person of interest in SC's disappearance based on pending civil litigation, wherein SC was defending against a civil lawsuit brought in 2019 by Dr. Kozowski against various doctors and surgical facilities. He was purportedly connected circumstantially to the location where SC was last known to have been located. Numerous factors from SC's past indicate that SC's disappearance may well have been of his own doing and or not the result of foul play. Okay. Looks like what they're trying to suggest there is he's not been murdered. It's quite interesting to be making that argument, of course, because we don't know where Steve Cozzi's body is. So anyway, on or about April 27th, 2023, despite SC not having been located, Dr. Kozowski was indicted on one count of murder in the first degree. The state has filed a notice of intent to seek the death penalty. The indictment reads as follows. In the county of Pinellas and state of Florida on the 21st day of March in the year of our Lord 2023, in the county and state or aforesaid unlawfully and from a premeditated design to effect the death of Steve Cozzi, did by a criminal act or agency, a better description of which is to the grand jury unknown, inflict upon the said victim mortal wounds of which said mortal wounds and by the means aforesaid, and as a direct result thereof, and the said victim died, contrary to Chapter 782.041A, that's the first degree murder provision of the Florida statutes, and against the peace and dignity of the state of Florida. So here's where we go with this argument. The indictment fails to include a definite written statement of the central facts constituting the offense charged, and then they cite the corresponding federal Florida criminal procedure rule. It likewise fails to adequately provide Dr. Kosowski with fair notice of the charges against him. There is a probable cause affidavit, but in any event, as set forth in greater detail below, the indictment is so vague, indistinct, and indefinite that it is fatally defective as defined under Florida case law, wherefore they request that they dismiss the indictment. So I'm not going to go through all of the legal precedents, but I will say a couple things. So first, they start off with citing to some U.S. and then state of Florida precedent on basically the standards of due process and, basically what an indictment needs to include. And here they're saying that Florida courts have long held that a charging document is so vague, indistinct, and indefinite as to mislead the accused and embarrass him in the preparation of the defense or expose him after conviction or acquittal. That's citing a specific provision in the criminal procedure rules that I'll get to when we get to that portion of my thoughts. But anyways, they cite a bunch of cases. In this instances, the defendant may challenge the indictment in a motion to dismiss. And here's the other thing. In addition, courts can dismiss an indictment if the court shall be of the opinion that the indictment or information is so vague, indistinct, and indefinite, again, this wording, as to mislead the accused and embarrass him or her in the preparation of a defense or expose the accused after conviction or acquittal to substantial danger of a new prosecution for the same offense. Okay, that part's not going to work because he's only been charged with one offense. But in any event, then they go on to state some general statements of law from some U.S. Supreme Court precedent. And then they cite the rule again. And we'll go through this rule that there is wording that says there needs to be a definite written statement of the central facts. Now, what that has been meant to mean under both U.S. law and Florida law is what we're going to go through. But that is the wording of the criminal procedure rules. Then they cite a 1898 Florida Supreme Court case. And they basically said, with respect to an indictment for murder, the Florida Supreme Court has held it is essentially necessary to set forth particularity the manner of the death and means by which it is effected. And I looked up that case from 1898, and yes, that is what the holding was. Remember, this is 1898, and this was a common law case that was decided before Florida enacted its rules of criminal procedure. And then they talk about this case where the court in 1898 found that they needed some more particularity about the way the murder occurred. And actually, in the case that they cited, the court found that it was sufficient and not insufficient because they did go through all this detail. But again, this is from 1898 and this is common law. So you notice also they didn't cite a single case that purports their same proposition, that in this situation, under current law, the grand jury indictment as drafted is insufficient. So it's very important to see they didn't cite anything here that is really on point to their particular case at this state of the law. So then they just basically say the indictment filed in this case simply fails to put Dr. Kosowski on adequate notice of the alleged acts underlying the charge. It's not necessarily what you have to do, but we'll get to that. To be sure, the state is purely speculating that the victim is deceased. Now, that being said, it is true that cases where the prosecution where there is no body, they can be more difficult to prove, but they can be proven. And there's a number of instances in Florida and throughout the US where people have been found guilty of murder even when a body has not been found. So, but I guess they have to bring that up, right? That's something that they can use to argue for their case. To be sure, the state is purely speculating that the victim is deceased. I'm not so sure about that. Of course, we don't know all of the evidence that has been uncovered and taken by the police in their investigation, and we won't know that until trial, right? We know from the probable cause affidavit that we went through in my first video on this case that there was blood evidence. There was evidence of blood in the car that was found in the defendant's garage, and other pieces of evidence that were cited in the probable cause affidavit. So um, I think the problem is that we don't have a body and we don't know necessarily the manner in which Steve Cozzi was actually killed. If you recall that the police, when they um, arrested Dr. Kosowski, when he returned to Tarpon Springs, they found a bullet vest. They found in his car, his second car, they found brass knuckles. They found a syringe with some type of agent that might be used to put someone under. They found a taser. So, in any event, it is speculating even further that Dr. Kozlowski committed some unknown act that would have caused the victim's purported death. The indictment then merely alleges that mortal wounds were inflicted on the alleged victim. The indictment seemingly even recognizes its own vagueness as it further states that the death of the victim was caused by a criminal act or agency, a better description of which is to the grand jury unknown. And again, I'll get into what's required to be pled in the indictment. Don't have to go this particularity. And in fact, because we don't have the body, we don't have a cause of death. We just know that it was likely mortal wounds. So in any event, a better description, which is to the grand jury unknown. Given the generic and unclear text of the indictment, no reasonable person could be on adequate notice of the alleged crime he or she purportedly committed. As the higher courts have recognized for well over a century, what having such basic knowledge, a person cannot adequately defend against the prosecution's accusations. Okay, well, what are some examples of these courts that are recent ever since the federal rules of criminal procedure and the Florida rules of criminal procedure were promulgated? As set forth above, the indictment wholly fails to inform Dr. Kozlowski of any particulars alleged offense to enable him to prepare a defense to the generic allegation that the state asserts. The indictment does not even sufficiently charge that a crime occurred, much less that Dr. Kozlowski would have carried out some act to have committed it. Is therefore fatally defective, is overly vague, indistinct, and indefinite. Permitting the state to proceed on the indictment would violate Dr. Kozlowski's rights under the 5th, 6th, 8th, and 14th Amendments of the U.S. Constitution and Article 1, Sections 9, 16, and 17 of the Florida Constitution. And you'll see here one of my updates at the end of the video is Dr. Kozlowski has actually added 2 more lawyers to his defense team. Okay, so there's the motion. So essentially what they're arguing is that the indictment doesn't adequately here allege the essential facts concerning the offense charged. So first we go, well, what does that mean? What do we mean by that particularity? So going to the committee notes, we'll see that they were adopted in 1968, well after that 1898 Florida Supreme Court case based on common law, not criminal procedural law. So there you go. But let's go down to what the committee said on this, the nature of the allegations themselves. So the charge, allegation of facts, and citation of law violated. This proposal is consistent with various sections of Chapter 906 Florida statutes in that the charge is adequately alleged when based on the essentials of the offense. So you need to adequately state the elements of the offense, here, first degree murder. Surplusage should be guarded against. And so the purpose of this is to allow, both under the federal rules of criminal procedure and the Florida rules of criminal procedure, to allow um, a plain, simple way of pleading indictments, in contrast to the lengthy way that things were done when we were only based on the common law. So what it says specifically following is the citation of the law allegedly violated contributes to defining the charge and concerns time in ascertaining the exact nature of the charge. And then they say the 1963 Illinois Criminal Code, they look to another state, and the federal rules of civil criminal procedure 7C contain similar provisions. So there, right there, we know that based on Florida law, the drafters instituted this charge to be a kind of basic pleading requirement, and that generally the law, citation, the law itself, and those elements is generally sufficient. Okay. They also talk about the federal rules of criminal procedure, 7C. So I thought we would just look at that real quick and see what the federal rules of criminal procedure require as far as the allegations that must be included in an indictment. So, with respect to the federal rule of criminal procedure 7C, based on US Supreme Court precedent, it's been made very clear that in the criminal pleading standard, an indictment promoting the language of the federal criminal statute is often sufficient. And indeed, the federal rules were designed to eliminate technicalities in criminal pleadings and are to be construed to secure simplicity in the procedure. While detailed allegations might well have been required under common law pleading rules, they surely are not contemplated by Rule 7C, which provides that indictment shall be a plain, concise, and definite written statement of the essential facts constituting the offense charged. So, what that makes clear is that under the federal rules of civil criminal procedure and under the Florida rules of criminal procedure, that says right here that generally speaking, providing the basis of the elements of the charge of the murder, here, murder, that is generally sufficient. So let's look and see what those elements of first degree murder are in Florida. Okay, so here you'll see that murder 1A, the unlawful killing of a human being when perpetuated from a premeditated design to effect the death of the person killed or any human being. Okay, so that's what Dr. Kosowski has been charged with. So let's look now. Pretty simple stuff, right? Let's look and see what the grand jury indictment says. Okay, so here's the indictment. And so again, thinking back to that murder definition, in the County Pinellas and State of Florida on the 21st day of March in the year of our Lord, 2023, in the county and state aforesaid, unlawfully and from a premeditated design to effect the death of the victim, did by a criminal act or agency, a better description, which is to the grand jury unknown at this time, inflict upon the said mortal wounds, of which said mortal wounds, and by the means aforesaid, and as a direct result, that person died. That's pretty much what the murder, that tracks basically the language of the requirements of what first degree murder is in Florida. So I just don't see this argument winning. You know, I don't think that these specific facts that Dr. Kosowski is trying to claim are required, is required under the Florida criminal rules of procedure. So again, Based on this, the fact that it's not what the Florida rules of criminal procedure require, that every act has to be alleged in the grand jury indictment. Um, the defense hasn't given us any case law that helps them in this regard, and I don't think the court is going to um, give them an out with this last provision of the rules on indictments that says no indictment or information or any count thereof shall be dismissed or judgment arrested or a new trial granted on account of any defect in the form of the indictment or information or a misjoinder of offenses, unless the court shall be of the opinion that the indictment is so vague, indistinct, and indefinite as to mislead the accused. He's been charged with murder. I don't think that's going to mislead Dr. Kosowski. Or embarrass him or her in the preparation of a defense. I don't see that applying. Or expose the accused after conviction or acquittal to substantial danger of a new prosecution for the same offense. That doesn't apply. There's one person. There's one charge. There was one person allegedly murdered and one charge. So I just don't see them winning on that argument. It'll be interesting to see what the state files in their response, but I just don't see them winning on that one. So let's go ahead and flip now to the motion to set bond, which I also think will not be granted. But let's go ahead and go through that together because it has some interesting allegations in that motion as well. Okay, so here's the motion to set bond. But first, taking a step back, in Florida, generally a defendant can file to have a pretrial release, except for those who are alleged to have committed a capital or life felony, and the presumption of guilt is great. So here, Dr. Kosowski has been charged with first-degree capital murder. So generally speaking, he would be required to remain in jail, not out in bond, unless they can show that unless the defendant can argue that there's no high presumption of guilt for him. So let's go through and see what they say. So defendant by and through their counsel respectfully move the court to enter an order setting bond, and here's their grounds. So on March 26th, defendant was arrested on one count of murder in the first degree. On March 27th, defendant appeared before this court, and the court ordered the defendant to remain in custody at zero bond. And then here on or about April 27th, the defendant was indicted on one count of murder in the first degree, a capital felony. And then, of course, on or about April 28th, the state filed its notice of intent to seek the death penalty against the defendant. Under Florida law, specifically Article 1, Section 4 of the Florida Constitution, anyone accused of a crime is eligible for pretrial release unless they stand accused of a capital offense or an offense punishable by life in prison, and the state of Florida can establish by evidence that proof of guilt is evident or the presumption of guilt is great. And then they cite some law when a person is charged with a capital offense. It's the state's burden in order to foreclose bail to present evidence beyond the indictment or information which shows the proof of guilt is evident or the presumption is great. And so it's kind of even a higher standard than what you would have to show at trial. So now we go into the factual basis of why they're bringing this motion. So first, they say defendant is originally from Poland. When the defendant was 2 years old, his parents sought refuge in Berlin, Germany, from the armed conflict erupting in Poland at the time. After living in Berlin for a brief period, defendant's parents made the decision to immigrate to the United States. Defendant was approximately 7 years old. I don't know what that adds to anything. I think it's just trying to make him look really good. Defendant spent his early childhood years in the greater Kansas City area before the family moved to Albuquerque, New Mexico, where defendant spent the latter half of his childhood. Defendant attended and graduated from high school there. Okay, that's just showing he doesn't have any ties. That's just showing he doesn't have any ties from childhood to Florida. After graduating high school, defendant went on to attend college at the University of New Mexico, where he earned a bachelor's degree in music, a bachelor's degree in biochemistry, and a master's degree in biomedical sciences. Defendant then relocated to England, where he attended medical school at the prestigious Dartmouth College, Geisel School of Medicine, as if, him attending a prestigious school makes a difference. Defendant also attended the Tufts School of Business during his time at Dartmouth. Defendant graduated from Dartmouth in 2007 with an MD and an MBA. He went on to hone his surgical skills at Dartmouth Hitchcock Medical Center, where he completed a general surgery, plastic surgery residency program. And then he did some surgical fellowships at Memorial Sloan Kettering in New York, the Miami Breast Center, and the Mark Codner Plastic Surgery in Atlanta. Up until his arrest for the crime for which he stands accused, defendant was engaged in a successful career as a plastic surgeon. He was definitely a plastic surgeon. I'm not so sure it was successful at the time of the murder because, as I said in my first video, I think there were some financial issues going on. Go listen to that video for more of my discussion on that, including the fact that at the time of the murder, defendant was representing himself pro se in that civil litigation that he had brought against his former employer, in which Steven Cozzi was the lawyer. So anyway, defendant has been practicing medicine for 8 years. That's not even that long. 3 of which were in the Tampa Bay-area. After a brief time working for Basson Center for Plastic Surgery in Tampa, defendant began working at the Lawfer Institute of Plastic Surgery in Dunedin, Florida in 2017. And that's the defendant he's suing in the civil case. After leaving the Lawfer Institute in 2019, defendant split his time between his primary residence in Tarpon Springs and Miami, where he was practicing medicine. And remember in that prior video too, I talked a bit about why was he practicing plastic surgery way down in Miami, and he lives super far away up, on opposite coast in Central Florida. Anyway, defendant does not have any prior criminal history. Okay, that's helpful. Defendant has strong community ties. His primary residence is a home in Tarpon Springs, which he purchased in 2018. Defendant owns the home free and clear and has resided there for approximately 5 years. If released from custody, defendant plans to reside in his primary residence with his 3 dachshunds, Gibson, Rigsy, and Ozzy. Okay, y'all, I love fur babies. I mean, you sometimes see my cutie patootie in videos, so I love dogs, but I don't know. That being said, I don't know if your significant contacts to the community and therefore will not flee is the fact that, you've got this nice home and you've got 3 dogs. Defendant is a citizen of the U.S. He's willing to surrender his passport. Defendant is willing and able to comply with any and all conditions of pretrial release this honorable court deems necessary. And additionally, he has the means to pay for electronic monitoring. Defendant is willing to personally appear for all future court appearances, should his presence be required. In the instant case, the allegations made by the state of Florida and disclosures thus far do not support a finding that proof of guilt is evident or the presumption of guilt is great pursuant to State v. Arthur. Therefore, defendant is entitled to reasonable bond. So what is going to happen here is we'll likely have an Arthur hearing. And if you have been following the Charles Adelson case, you'll recall that there was an Arthur hearing held in that matter. And ultimately, the court actually did not grant the defendant, Charlie Adelson's motion for pretrial release at the conclusion of that Arthur hearing. So I think that's what we're going to have here. And then here is basically they're citing the case law as to why they should be, he should be let out on bail. And, they are arguing that based on all these various factors, the mitigating factors, they clearly demonstrate that he is entitled to a reasonable bond because of his age, his life history, ties to the community. I mean, I don't know. I would argue, besides the fact that he owns some luxury home that could be sold like that in this Florida real estate market, I don't know what those reasonable bonds to the community are. I mean, at the time of the alleged murder, he was working in Miami. He wasn't working in Pinellas County. There's no allegations that he has any family locally other than the 3 pups. I don't know. As discussed above, okay, so established that he would not pose a risk of flight or danger if released. I don't think that's going to be a winning argument. I really can't wait to see what the prosecution's response is to this because, like I said, I don't know that an expensive home that you could probably sell pretty quickly and three dogs is going to be enough to convince that, for such a serious crime and all of the allegations that we have in that probable cause affidavit, I just don't see that to be a winning argument. I don't know. What do you think? The other updates in the case is, as I mentioned when we were going through the motion to dismiss the indictment, Mr. Kozowski has added two lawyers to his team. Now, his first lawyer is a criminal defense lawyer, and he is also board certified in criminal trial by the Florida bar. His other two attorneys that he added in May, they're both criminal defense attorneys, and one of them also has that board designation by the Florida bar. So he's brought in three lawyers. I think probably because since this was, now the state has brought its intent to bring a death penalty case, my assumption is that um, his original attorney was like, even though he's very experienced, and my assumption is that due to the nature that a potential death penalty trial would bring, I'm assuming that's why he brought on more lawyers. But he brought on more lawyers, so that's something to be interested in. The other thing is I want to provide a quick update on the civil case. So if you recall from my original video, there were a number of motions pending at the time of the murder, including some motions that Dr. Kozowski filed the morning of the murder and the afternoon of the alleged murder regarding the matter. Well, to be short and sweet, they were all denied. You'll recall one of the really serious motions that Dr. Kozowski had brought was a motion for sanctions against the defense and specifically asking to remove Steven Cozzi from the case. So all of those motions have been denied, which I'm not surprised. I didn't think that there was much of a basis for the motions in any event. But what is also interesting is that in May, his criminal attorney appeared in a limited basis in that civil case just to appear. And then subsequently, Dr. Kozowski has retained a private lawyer to represent him once again in that civil case. So you'll recall that at the time of the alleged murder, Dr. Kozowski was representing himself pro se. And as I mentioned in my prior video, that was part of the problem, right? It didn't seem as a non-lawyer, he really understood how discovery works and just, which again, I think I said back then, to no fault of his own, but then again, it's like, why are you representing yourself pro se in a civil case that you brought as plaintiff against your former employer? So, it's interesting that he has brought in a lawyer to now represent him in that matter. Thank you so much for joining. I really appreciate you coming back and listening to my content. I really love doing this, and I appreciate each and every one of you, the time that you take away from your day to listen to listen to what I have to say about law and crime. And if you wouldn't, on your way out, if you wouldn't consider subscribing if you're not already subscribed, or liking and leaving a comment, it really helps the algorithm, and I'm trying hard to grow the channel. But thank you so much, and I hope to see you in my next one. Bye.